Greetings. As I mentioned in the last mini lecture, this debate between the nation-centered and the state-centered view of federalism is really a debate about this notion over whether the national government has implied powers or not. In the last mini lecture in McCulloch versus Maryland, John Marshall, who was a believer in the nation-centered view, uh, allowed the national government to charter a bank. He would not allow the state of Maryland to tax them. And in McCulloch versus Maryland, as I pointed out at the end of the last mini lecture, you get the doctrine of implied powers established. John Marshall takes a very broad interpretation of national power. And this lasted up until his death in 1835. And at the end of the last mini lecture, I told you that when John Marshall died, Andrew Jackson was the president. Andrew Jackson nominated Roger Taney, and you can see Roger Taney was Chief Justice for 28 years, from 1836 until 1864. And I want to just step back for just maybe 45 seconds or a minute away from federalism to get you to think about something. Take a quick look at the dates of when John Marshall was Chief Justice and when Roger Taney was Chief Justice. So John Marshall was Chief Justice from 1801 to 1835, and then Roger Taney from 1836 to 1864. So between these two men, they were Chief Justice of the Supreme Court for almost, not quite, almost 2/3 of a century. From 1801 until 1864, there were only two Chief Justices of the Supreme Court. Now contrast that with presidents. From 1801 until 1864, we had 14 presidents of the United States and only two Chief Justices. So when Richard Nixon was asked, "What do you think is the most incredible power that you have as president?" Mr. Nixon surprised the reporter by saying, "It is the power to nominate Supreme Court justices. For my justices will not only serve long after I am no longer president, but probably long after I've died," which in this case was true. Mr. Nixon had one of his nominees to the court, Mr. Rehnquist, who served for 12 years after Mr. Nixon had died. So these Supreme Court Chief Justices can be in office for a long time, and it is probably the most awesome, long-lasting power of a president. And so it's intriguing. We have a presidential election coming up in November of 2020. I'm making this video in August of 2020. And the shaping of the Supreme Court may be, in the long run, the most important issue in this presidential election, and yet very few people are talking about it. And I'll talk more about this when I get to the Supreme Court later. So I want to talk about the state-centered view of federalism. And really, there are two things that you need to know from this mini lecture. And the first is that people who believe in the state-centered view of federalism, their holy grail, the provision of the Constitution that is most important to supporting the state-centered view, is the 10th Amendment. So when I ask you on the exam, Roger Taney invoked what constitutional provision to protect the power of the states, the answer is the 10th Amendment. If you read the 10th Amendment, right, it says that those powers that are not granted to the national government belong to the states and to the people. And that's why people like Thomas Jefferson said, I don't believe that the national government has the right to charter a bank because it's not mentioned in the Constitution. And if it's not mentioned in the Constitution, it is a power that belongs to the states. Okay? And that was the view of Roger Taney. If the Constitution specifically granted that power to the national government, if it was enumerated, then the national government, yes, was supreme. But if the Constitution was silent about an issue, Taney's view was that belonged to the states. The most famous illustration of this state-centered view was in Dred Scott versus Sanford. I'm going to talk about Dred Scott versus Sanford in more detail when we get to civil rights. Dred Scott, of course, had been a slave. He'd been owned by an army doctor, Dr. Anderson. And certainly there is a civil rights component that's very compelling. And that's usually the part of the case that's emphasized, and I'll talk about it in civil rights. But probably the more significant aspect of this case involves federalism. It's the part that usually isn't explored as much, but I think it's even more compelling. So I talked about slavery earlier, and I told you that it was my belief that slavery was the great silence of the Constitution, that slavery was only dealt with on the margins, and essentially history would decide the future of slavery. The country kind of kicked the can down the road, and by 1850, there were a lot more people living in the northern free states than in the southern slave states. So the free states had a huge advantage in the House of Representatives. The free states had a huge advantage in the Electoral College electing presidents. The only place where the slave states were still equal to the free states were in the Senate. In 1850, there were 15 slave states and 15 free states. So there were 30 senators from slave states and 30 senators from slave states. In 1850, the United States had a problem child. Every family has one. In my family, I was the problem child. But in 1850, the problem child was California. You see, today we think of California as being this absolutely centerpiece of American society. California has more people than any other state, so we have more House members, we have more electoral votes, we have the largest economy. In fact, if California were a country, it would probably have something like the sixth largest economy in the world. It's an entertainment center. And yet, for most of California history, California was a neglected stepchild. Spain first colonized California. I'm talking about European colonization. And yet Spain did not establish a permanent settlement in California for 200 years after Spain discovered California with the creation of the San Diego mission and Presidio. And of course, Spain then proceeded to set up the mission system. And if none of you have ever gone and seen the missions, you should go do so. It is the treasure of the Spanish period, and certainly they're very, very interesting. And I haven't visited all of them, but I visited a majority of them. Of course, Mexico declared independence from Spain, and Mexico took over California. And Mexico, like Spain, did not see California as particularly important. In fact, Mexico essentially bribed people to come to California, establishing the rancho system. When I lived in Sacramento, the most famous of these ranchos was the 48,000 acres that was given to a Swiss immigrant, Sutter, and you can still go visit Sutter's Fort. And my wife and daughter used to every year go to Frontier Night, where they would kind of do a reenactment. My daughter and wife would spend the night at the fort, living as if it was the period under Mexican political control. Mexico, of course, lost California to the United States in the Mexican-American War. The United States took what was then kind of the northern half of Mexico. And the United States wasn't sure what to do with California until the gold rush hit. And then there was a huge emphasis on trying to get California into the Union. The problem, of course, was southern states were leery about California becoming the 31st state. California wanted to be a free state, and this scared Southerners. There was a very elaborate compromise that was established called the Missouri Compromise. Your book talks about its details, but essentially a geographic line was established with territories to the north being free, territories to the south being slave, and now Congress believed that it had resolved the slavery question forever. In this case, forever turned out to be 7 years. That's it, 7 years. And so the question was this legal? Did Congress have the right to regulate slavery in the territories? Or was this a power that belonged to the people who lived in each state? That question of popular sovereignty. To make a very long and very interesting story short, the Taney Court declared that Congress could not regulate slavery in the territories. For the first time in American history in this case, the U.S. Supreme Court struck down a major federal law. And when this case was being decided, all of the experts essentially said Congress has only declared one minor federal law illegal, and that was all the way back in 1803 in a case I'm going to talk about later called Marbury versus Madison. The Missouri Compromise was a landmark piece of legislation, and very few, if any, people believed that the Taney Court would strike it down and declare it unconstitutional. But that is exactly what happened. Now, a lot of historians say that the decision in the Dred Scott case made the Civil War inevitable. I personally don't believe that. I believe that if we had had an able president in 1857, that good diplomacy could have possibly prevented the Civil War. But unfortunately, in 1857, we had a horrible president, a man named James Buchanan, who believed as president he did not have the power to intervene. He did not have the power to keep the states from leaving the Union. And of course, the result was absolutely disastrous. So what should you know for exam purposes in this state-centered view of federalism? You should know two things. First, you should know that if you are a believer in the state-centered view of federalism, the provision that you are going to look to is the 10th Amendment. And that is what Justice Taney did. He invoked the 10th Amendment to protect the power of the states. The second thing you should know about the Taney Court in this state-centered view of federalism leading up to the Civil War was that the Taney Court declared the Missouri Compromise unconstitutional, circled the words that the Taney Court declared that Congress could not regulate slavery in the territories. This was not an issue, according to Justice Taney, that Congress had the right to regulate, and instead was a states' rights issue. That people who lived in the various states, people who lived in the various territories, the people who lived in those states had the power to determine the future of those states and those territories, and not the Congress. So this was a major reversal. I want you to think about this. Because if John Marshall had been Chief Justice in the Dred Scott case, he would have said, this is a commerce issue. Slavery is legal. Slaves are transported across state line. Congress can regulate it. It's part of interstate commerce. If Justice Taney and his group had been there for the McCulloch versus Maryland case, they would not have allowed the Bank of the United States. So in this case, the Constitution was the same in both cases, but what was different were the Chief Justices who were interpreting it.